Good evening. My name is Nate Grasz. I'm the policy analyst for the Nebraska Family Alliance, 1106 East Street, Lincoln. And our organization represents a network of thousands of families across the state, many of whom live here in Omaha and send their children to OPS schools. I'm here tonight to address Policy 1200 and Agenda Item J1B, which would impact student access to restrooms and locker rooms. We sympathize with children who have difficult issues to work through, but no child should be forced into an intimate setting like a restroom or a locker room with another child of the opposite sex. The very first sentence in this policy states that OPS intends to comply with all state and federal laws prohibiting discrimination. So what do federal and state law require? In May of this year, the Obama administration attempted to redefine sex in Title IX to include gender identity. In short, this was an egregious overreach by the federal government. The guidelines are non-binding and do not accurately represent federal and state law or what the courts have decided. 24 states, including Nebraska, have filed a lawsuit over this policy. A practical approach would be to wait and see how the federal courts rule on this issue before making a policy change. This is what other school boards across the country have done, such as Fairfax County School Board in Virginia, who recently announced that the district would hold off on implementing this controversial policy while waiting for the outcome of the legal challenges from the 24 states. Title IX was passed in 1972 with universal recognition that it was intended to ensure equal opportunities for biological females. The law even clarified that separate changing and bathroom facilities for women were obviously not discrimination, and the regulations implementing Title IX specifically allow schools to provide separate toilet, locker room, and shower facilities on the basis of sex. This is made abundantly clear under Nebraska law, where state statute says the Nebraska Equal Opportunity in Education Act does not prohibit any educational institution from maintaining separate toilet facilities, locker rooms, or living facilities for the different sexes. There is a constitutional right to bodily privacy, to not be viewed unclothed by those of the opposite sex, and this right has been upheld for children at school, employees at work, and even convicted felons in prison. Both federal and state courts have almost uniformly rejected arguments suggesting that Title IX requires schools to give students access to opposite-sex restrooms and locker rooms. Just last year, federal courts in Pennsylvania and Missouri rejected students' claims that Title IX required their schools to allow them to use opposite-sex restrooms. The Supreme Court has also now intervened for the first time on this issue, granting a Virginia school board permission to keep its bathrooms separated by biological sex and blocking a lower court ruling that would have allowed students to use the school restroom that fits their gender identity. And it's not just student rights at stake, but parents' rights as well. The U.S. Supreme Court has also ruled that the Constitution protects the fundamental right of parents to make decisions concerning the care, custody, and control of their children. Under no circumstance should schools operate under the mistaken belief that President Obama's guidelines, Nebraska State Law, or Title IX require them to treat sex as irrelevant to the restrooms, showers, or locker rooms that students may access. In fact, the courts have found the opposite. Student bodily privacy is a constitutional right that schools have a responsibility to protect. Therefore, schools should craft policies that are both respectful of the constitutional privacy rights of all children and sensitive to the diverse needs of individual children. Thank you.